Welcome back to another episode on Legal Stories. Today we're looking at the case of Pius Chilufya Kasolo versus ZCCM Investments Holding PLC, a landmark decision delivered by the Court of Appeal of Zambia on November 28, 2024. Our story begins with Dr. Kasolo, who served as the Chief Executive Officer of ZCCM. He was serving the second term of his contract for a period of 36 months. However, on February 1st, 2019, his employment was suddenly ended. The company issued a termination letter stating that they needed to pave way for a new chief executive officer to run with a new strategic plan. Dr. Kasolo believed this was a smokescreen. He pointed out that just days before his termination, he had responded to a journalist regarding the effects of a proposed sales tax. This led to media articles branding him a traitor. The manner of his firing was extraordinary. It was announced on national television during a press briefing by the Minister of Mines and the press aide to the then Republican president, before he had even received his formal letter. While ZCCM paid him 3 months' basic salary in lieu of notice, Dr. Kasolo argued his termination was unlawful and lacked a valid reason as required by law. He originally lost his case in the High Court. The High Court judge used a Google search engine to define operational requirements and concluded that, since a strategic plan is an operational document, the company's reason was valid. Dr. Kasolo then appealed to the Court of Appeal. The Court of Appeal focused on the Employment Amendment Act No. 15 of 2015. They looked at 3 critical rules. Number 1, the duty to give a valid reason. Under Section 36, subsection 3 of the Act, an employer must provide a valid reason for termination connected to the employee's capacity, conduct, or the operational requirements of the business. Number 2, burden of proof. It is the employer, not the employee, who must prove that the reason for firing is valid and substantiated. Number 3, the notice clause. The court clarified that a notice clause is no longer an escape clause that allows an employer to bypass the requirement for a fair reason. The Court of Appeal found that the High Court judge was way off the mark. They made the following observations. Number 1, the Google error. They ruled that the judge's reliance on a Google search instead of established legal authorities was flawed and had no basis in law. The contradiction. The court found it not far-fetched to conclude that operational requirements had nothing to do with the firing, because the board chairman who signed the firing letter had actually written a foreword to the strategic plan, heaping praise on Dr. Kasolo for fashioning the very vision they claimed he couldn't run with. Traumatic dismissal. The court cited evidence from the record showing Dr. Kasolo was mercilessly trolled on social media, with people calling him names. Because the firing was announced on national TV and led to this public mental torture, the court labeled the dismissal traumatic. The Court of Appeal set aside the High Court's decision and ruled that the appeal succeeded on all 7 grounds. They awarded Dr. Kasolo 6 months' salary as damages for wrongful dismissal, plus interest. What are some of the lessons we can learn from this case? Number 1, notice is not a shield. In Zambia, you cannot simply pay off a contract to avoid giving a reason. Even with notice pay, the reason for termination must be valid and proven. Number 2, operational requirements must be proven. A company cannot just say restructuring or new plan as a cover. They must provide evidence like financial records or proof of a restructuring exercise. Number 3, the how matters. Terminating an employee via a public TV announcement or in a way that invites public ridicule can lead to higher damages for mental distress and trauma. Thank you for joining us on this episode of Legal Stories. Don't forget to like, follow, and subscribe to our YouTube channel.